to order. Thank you all so much for taking here today. The first agenda item, I just wanted to do a little bit of a recap. I'm hoping that, body camera will be solidified in the next meeting or two, and then we can move on to other things that the implementation committee was tasked at. So I just wanted to make sure we're all on the same page with where we're at with everything. So on the document we've been working off of, number 1, number 2, and number 6 are currently on hold, pending. Sheriff, do you want me to give an update on where we're at with meetings, or do you want to go ahead and do that?
You can go ahead. It'll be easier for you to do it. Okay.
So we met as a group, Sheriff Bartlett, myself, Supervisor Benvenuto, Supervisor Lagonia, and our labor attorney met just to kind of go over updating Supervisor Benvenuto, our labor attorney, and Supervisor Lagonia specifically as far as where we're at thus far in the conversations. And we have a meeting scheduled for the beginning of November with the union. So hopefully we'll have more to update after that, but that's where we're at with those. On the same document, number 5, number 7, and number 8 have already been agreed to be added to the sheriff's office body camera policy, agreed to by both the sheriff and the implementation committee. Sheriff Bartlett and I will be working on kind of drafting that language into the policy. I know Sheriff Bartlett, we need to make a time to do that outside of this meeting, but my goal, if it works for you, is to have something either in place or ready to be in place by the next meeting, which is 3 weeks away. Does that work for you, Sheriff?
Yeah, we can sit down and talk about it. We'll just have to, I got to get you tied down.
Yeah. I'll touch base with you after the meeting and maybe we can find a time.
That's fine. I chuckle because the supervisor's so busy. That's why she's involved in a lot of stuff. So.
All right. Well, we'll make that our goal to get it either in the policy and adopted before the next one or ready to go before 10, I think it's 26. And then number 3 and 4 are on the agenda for discussion today. And then pending the resolution of those, either Sheriff Bartlett and I will work on incorporating whatever's agreed to on those also when we work on incorporating it. And at that point, hopefully we'll on the other 3 and be ready to move to the next topic. Any questions from anyone on where we're at thus far? Okay, so 2 meetings ago, I think we were in person at that point. We were talking about number 3, which talks about setting a firm deadline for the release of all properly redacted body camera footage just for use of force incidents. There was some conversation regarding, pending prosecutions and the DA's office. There was some conversation about FOIL and how to word such a thing so that it was clear that it doesn't usurp any, legal requirements of the DA's office for discovery or otherwise. So Supervisor Chimides was tasked at finding other municipalities that had some sort of deadline specified in their release policy and taking a look at how they word it, how they get around some of the concerns that were raised. Supervisor Chimides did come up with quite a few documents. Thank you, Supervisor Chimides. He came up with a document that was a recommendation to this committee after doing the research that he did and talking about, what the sum of his findings were. He also included Assembly Bill 748 from the state of California regarding footage release, a model act for regulating the use of body-worn cameras by law enforcement by the ACLU, as well as City of New York and City of Chicago policies. And I'm just going to actually turn the floor to Supervisor Chimides to do a quick recap of his findings and then answer any questions that any of the committee members might have.
Yeah, thank you, Supervisor. So first, I just wanted to frame what we're trying to accomplish and what the key things. The reason why we're here with the Police Implementation Committee was sort of in the aftermath of the George Floyd killing. Is this sense of there are times when officers behave inappropriately. And it's not, it's not about, this is not a critique of the entire police force and the entire department, and not necessarily even any criticism of the county police force, but we know that there sometimes is, you want to have a mechanism to capture if there is a misdeed, and we want to be able to make sure that that there's accountability for somebody who might be doing something wrong, but also that the public and potential victims have some sort of redress and have some sort of opportunity to know what's happening. And so the point of this policy is to say, well, if there is a use of force incident, there is some mechanism for people to determine what happened. And so the policies that I came up that I identified, the ACLU policy has slight differences with the other sort of municipalities that I presented, but pretty much all of them have some sort of mechanism of saying the default is when there's a use of force incident, which, where there's an officer using force, is that the person who sort of has some sort of mechanism to see the footage, and if that person is killed, though, like that person's family or that person's sort of representative has an opportunity to see the footage. And that's sort of the default. And then all of them have some sort of out clause that basically says, in the following circumstances, the authorities can put in writing an exception to this rule that basically prolongs or postpones the period before that footage would be released. And so the ACLU one focuses on releasing the footage to the relevant parties. So basically people who might be involved in the incident, people who are in the video, and people who might be charged have access, and their lawyers have access to the video footage. It's less about public release, but it's more about they have, and what they want to do with it is up to them, versus most of the municipalities have some sort of public release footage. Those are sort of two, but I think either way, we should at least pick one of them to say, at the very minimum, people involved in an incident are going to have quick access to the footage, unless we have a high bar. But if we have some exception, we can make an exception and put it in writing. So that's the basic framework. And if you want, I can go through sort of more line by line about like where that exists in the ACLU policy. The other municipalities have, they created entire policies specifically about release footage. So there's less line by line. It's just like, you can look at the entire document.
Thank you, Supervisor Chamides. Any questions for Michael?
I do. I have a question. As of right now, the district attorney's office is responsible for releasing evidence that it's going to use against a defendant within a very short window time frame anyway. I'm not sure, if in California they have that same kind of a rule, but I don't know how this is going to impact that.
Well, one area that might be different is that it's true that New York does have like evidence laws that the defendant has access to the evidence available. Is that there's potential situations where there's a use of force incident where the person who had force applied to them is not charged with a crime, in which case I think they wouldn't have the same access to something. Or if a person is killed, like they wouldn't be charged presumably either. So in some ways, like there are potential gaps to our discovery process that we haven't addressed yet. And I think a lot of this is like looking at worst case scenario. And so do we have a mechanism to address some of these worst case scenarios? And so basically I think it's not a big, since we already have discovery laws that are pretty ambitious about sharing evidence, it really just extends that to other people who might have experienced it. So it's actually the reach of it isn't that big considering we already have the discovery policies.
If I could, in regards to what Supervisor Berry just mentioned, it really doesn't get to the level of evidence, one, unless a crime, when you're in this sort of part of the phase, families or the representatives of the family themselves are trying to determine if the use of force was appropriate or not. And so the policies that Mike put in place, or Supervisor Chamides, excuse me, put in place, I think it really serves a purpose, because the ultimate goal that we're here is trying to do is to try to protect the public, and also the rights of the officers that are serving the public. So something like the ACLU is putting in place, I think is a good idea. Now, can it be tweaked? We could talk about that, but I think we have to have something in place to that nature. And like I said, it doesn't reach to the level of the DA until an actual crime is determined or charges are being considered.
Sheriff Bartlett, I saw a hand raised for you.
Yeah, anything with a death that by the AG anyways. If there was a death and where there was some type of a piece or plea involved in that death, the Attorney General will be looking at that. I just wanted to throw that out there so people don't think that if somebody died in the hands of a police officer, whether it was, let's take something like inside the facility. If somebody passed inside my facility, whether it was something that they did or something that a officer did, the AG would be involved in that. So I just didn't want that to be put on the table where it's saying, well, if there's a death, AG looks at all in custody deaths or deaths involving officers.
Thank you, Sheriff. One thing I'd like to say, I like Supervisor Chimiti's recommendation, and one thing I really like about it when I look at Chicago and New York City and kind of what the supervisor was evaluating is that it really leaves room for DA Chaika or Sheriff Bartlett or another organization or entity or level who had access to potentially saying this isn't going to work this time because of XYZ. So having that kind of out in there and just requiring that it be put in writing, because I think what Supervisor Chimiti was talking about with the public trust, even if at the end of the day it's very similar to our discovery laws, and when there wasn't actually somebody charged with a crime, it's putting it in writing. So whenever possible, we're going to get this to at least the victim and or their family, maybe the public, within a certain amount of time. But so that if DA Chaika says, wait a minute, we are bringing charges maybe against the officer or against the person who was killed, I need to not put this out there, and here's my reason why, and he's able to put it in writing. I feel like that kind of gets both things accomplished, which is making sure the public feels a certain trust and assurance in the process, that there's a process in place, it occurs the same way every time, it's defined, while also making sure that any concerns from a prosecution standpoint or a police standpoint are also able to be addressed on a case-by-case basis. Supervisor Bury.
I also agree that the New York City policy, the NYPD policy, looks pretty good. I think it offers everybody what they're looking to get. I want to make a point about what I said before. I wasn't looking to say that because it's going to be released as evidence that we didn't have to do anything. I just wanted to make sure that we understood that that's already on the table, that's already there. That's also a point that the sheriff made as well. But I think if we looked at the New York City, the NYPD policy, I think it's definitely something that we could tweak here.
Anyone else? Dave or Gary? Gary?
I have a question for Mr. Chimiti's. What does the ACLU version have that the NYPD doesn't, that include?
Well, the ACLU one is more focused on getting footage to the interested parties or the relevant stakeholders to the video or to the incident, while the other municipal policies are more focused about public release. So I think the ACLU policy is just more focused on the people involved in the incident. Like they have a right to see the footage and sort of, I think their analysis is more that maybe the person who was involved in the use of force incident, maybe they would want that video public, but maybe they wouldn't. And so I think the ACLU is we should prioritize, okay, this person was involved in use of force incident, or people, right? There's multiple stakeholders, and they're kind of the ACLU is less focused on does the public have a right to the footage, is more as like let the interested parties get access to the footage and then let them decide what happens with the footage, as opposed to saying like you have to do a public release. So that's the sort of the key distinction. Otherwise, I think they're fairly similar, where it's more like who are you giving the footage to, the public or the interested parties?
Yeah. So for instance, if I happen to be a bystander and I'm caught on camera and somehow affected by what's going on, this protects me. This gives me a chance to see what the camera saw in terms of my presence there or my possible involvement.
No.
I guess I'm not sure how bystander, like what, I don't know the exact legal standard of the ACLU of like when a bystander becomes involved. But I think they did have they do have clauses. They also, their body camera longer because it involves all of their different stuff. So I'm not as familiar. It's like harder to read through specific questions, but they do have some sense of like, if you're in the footage, you have an elevated right to see the footage and you have an elevated right to request it in general, but that might also be about like its retention policy as opposed to like its footage release. But in a general sense is that anybody in the video has a heightened way to access it. I don't know if they said, like if you just happen to be in the video, I don't know if that means that you can request it immediately if like you were basically uninvolved with the incident aside from like being randomly in it. But I think it probably, I don't know, there's probably not a good legal distinction between being randomly in it and in the center of it. So you probably have to kind of just do a blanket statement. If you're in the video, you have access to it.
Yeah, I like the idea of it being broad enough that we can make sure even if it's an elevated right, even if it's not an absolute one. I think that's worth including in this. If the NYPD is our model and we like that, but it doesn't include something like this, I think it would be a good idea to make sure we include that.
Thanks, Dave. Gary, you were next, and then Supervisor Bury. You can't unmute. So typically, if you're on a computer, if you move your mouse at the bottom, a bottom bar will come up, and on my screen, it's to the far left. It's a little circle with a microphone on it, and yours will appear with a line through it. And if you click on it, it should unmute it. No. I'll turn to Supervisor Bury, and Gary, you'll be next. Oh,
I was just going to jump in just to answer Dave's question. I found the text. It's page 3, section I-1. It does go through and enumerate who would have access to the video. And the text they says any person who is subject of body camera footage, and then it has some attachments like the parent of a minor or the next of kin and those kinds of things. All right, sorry.
I would think that there is a redaction policy out there, and it could be used in a case where you have someone that is a bystander and their face appears in one of these kinds of videos, that face would be blurred out. As for reaching the parties who are participating, caught in the video, they're actors that are in the video. I'm concerned that what I'm hearing here is we could have someone who has access to the video because they could be a perpetrator, and they say, well, you know what, I don't want that video released. So how is that serving? That's the way I'm reading this, that if anybody that's not law enforcement doesn't want to release this, they're a subject that's under investigation or something like that. What I'm hearing is they could say, I do not want the video released. How does that serve the public good when you're going to have people who are interested in the use of force? That to me is a concern. And I don't know what the NYPD policy does. I didn't see it. I just saw redacting innocent bystanders so that their images didn't appear. I would not be in favor of allowing anyone to say we're not releasing the video unless there's a legal reason for not doing it.
I understood it a little different, and maybe Supervisor Committe, I understood it to say that if our policy says it's released within a certain amount of time to victims, people involved, next of kin of the deceased, that not that they could then say, I don't want this released, but they could then release it to the public if they felt like that's what, was in the best interest for their family. Am I understanding that correctly, Michael? It's not that they could have the say of nobody can release this publicly, right?
Well, I think there's two different policies. So I think like the New York City policy and most of the municipal policies that I shared, the default is public release, and the people in the video don't have an option. The public doesn't have an option to not have it released. Like the default is that when there's use of force, this video is getting released, and the only brakes on it is the determination by the by the municipality. So like whether it's the district attorney or the sheriff's office or a law enforcement agency, there's like a long list of like governmental bodies that can put a brake on releasing the footage, and they may put the brakes on for various reasons, like an investigation or privacy or minors or whoever. So like there is a mechanism to put the brakes on, but that mechanism is not, they might be informed by the public, right? So the public could say, we don't want this video released, and maybe like the government itself could say, well, we're going to pause because of this. But ultimately, the public does not have power to hold off on releasing on their own in like the New York City policy. The difference, the ACLU policy is not focused on public release. It's just focused, so like the New York City policy says we're going to release it unless the government puts in writing that they want to hold off on releasing it. But at the end of the New York City policy, I think it inevitably ends in the footage being released, maybe with some people blurred out, but like all you can really do, I think, in the New York City policy is just prolong how long until it gets released. But I think generally with FOIL policy, the footage becomes available at some point anyway. So the New York City policy is like, that's the default. The ACLU policy is not focused on public release. It's focused on it's just focused on the stakeholders getting copies of it. So I think it's less clear about how the public sees it, and it's more clear about how the stakeholders and their attorneys or their families would see the footage.
Well, I have to ask a question. So if we were to go with a policy where we were to release it to the family, and then we left it, our policy said we'll leave it up to the family to release it to the public, I'm not sure that would work. You know, I think the public, the taxpayers have a right to see a video, and it may show a member of that family in a favorable light or an unfavorable light, but they have a right to see it. And if we're going to decide a policy for the county, we shouldn't have to, it should be, this is the policy. It will be released after X number of days with redactions as requested by that, or a delay to it, you know, that kind of a thing. But I don't think you start going this way and that way with it.
So yeah,
I was more just presenting options. I mean, I was asked to research the options, right? So like, we have two choices to make, but yes.
I agree with you, Supervisor Bury, and I think I agree with you too that the New York City policy, as I look at Chicago, New York City, California, is a good policy because it addresses a lot of the things that we're talking about, and it is a blanket, you know, it's going to be released and these things can be redacted. And sorry, Bill Hughes.
Yeah, no, I was going to say basically the same thing. The other point I was going to make is, it seemed to me like it could be a hybrid where you could have the release, like the ACLU, where the stakeholders along with law enforcement that would have access, but the tail end of how it gets released and who could stop it would mirror the New York policy more. So it's more of a hybrid of both.
Dave Hall.
Yeah, I was just going to say I agree too. I don't think a member of the public who happens to be in the video, whether they're a possible perpetrator or just not, I don't think they should have the power to say this can't be released. It's more about who has access to that, and I think all of these policies, as Mr. Committe says, really it's the stakeholders in government that have the ability to pause it. But I don't think a member of the public would have the ability to say this can't be released. It's not really appropriate. And as you said, Supervisor Bury, it's in the public's interest to see it, not for some member of the public to prevent it from being seen. So I think we're in agreement on that.
Agreed. So looking at the New York City policy as an example, does anyone have one that they think should be changed or edited? Any concerns with how it's written? Sheriff Bartlett and DA Chaika or Ryan Carty, especially, I'd love your input on that. Shane Zoney, some of the people who are in involved in that end of things. Captain Bray, anything from you?
I mean, I'd like to take some more time to digest the various policies that were provided to us. And, I'd like to see some kind of working draft, perhaps be, passed around that we could all have some input on and perhaps come up with something that's agreeable to everybody.
Okay. So what if we took the New York City one as a draft, and maybe between now and a week from now, any committee members and Captain Bray and Mr. Zoni and Mr. Chaika could send me any kind of red lines, or, here's an area we need to rework. And then maybe at our next meeting, we could present that draft again to the committee in our own wording. Does that work? If I give everyone about a week to really go through the New York City policy as the template, and then send me any edits, modifications, and then I can come to the next meeting to this committee with a draft.
I'm happy to give you my thoughts now.
Oh yeah, go ahead, DH.
Yeah, I would love to hear that. Yeah.
I happen to believe that the state legislature has preempted this entire field.
Can you expand that
Yeah, I
statement?
was thinking it.
That means all of these issues are enacted in the criminal procedure law. And the criminal procedure law is essentially the first and only word on the subject.
So if there was a case where there wasn't a crime and there was no prosecution, are you saying the criminal procedure law would still apply?
No. If there's any possibility of a crime, and as the sheriff will tell you, we always assume that conduct is criminal until we understand otherwise. Unless and until that happens, the legislature in Albany has preempted the field such that anything we do is meaningless, or anything this committee does, I should say.
Yeah, Mr. DA, I would think though, definitely when you're dealing with the public and representatives of the public, and I don't know what the legislature's law says. I think we all should get a copy of that and take a look at it, because it may, hamper or impede some of the things we are trying to do. But with that being said, assuming that everything is a crime doesn't necessarily always fits a situation, especially when you're dealing with use of force. Because use of force is interpretive, right? It could be a minor thing or it could be a major thing. A lot of times it could be incidents that are happening that is just leading to simple simple punishment, or simple some kind of thing that would go to the officer for misconduct, or it could have been that the perpetrator was actually doing something where it didn't lead to charges, or it led to charges, but not against the officer, but against the perpetrator. So I think this particular topic probably would go outside of the legislature's law, but that remains to be seen. But I think we definitely have, whether the legislature has a law or not, we need to have our own as a fallback.
Yeah, and New York City also is in New York State. So I would assume, unless New York City has different criminal procedure laws, that they're under the same state legislature, CPL as defined by New York State. We could put maybe a disclaimer line in there that says, this doesn't supersede any requirement by New York State criminal procedure law, or something to make, if that makes the DA feel more comfortable that we're not looking to usurp, not that we could, because we can't usurp the state's criminal procedure law, but we could put certainly a line in there that, acknowledges that the policy doesn't override anything defined by New York State criminal procedure.
I think we should do that anyway.
I mean, I guess I would also add on to that. I mean, you want policies. Policies are like the pieces that tell you how to do stuff. And so regardless of whatever the laws are, you need policies that reinforce those laws, right? So if the laws already exist, that there's certain things you need to do, you also need a policy manual that, because we don't expect every time like we're dealing with body camera footage that we're going to go check like the New York State code and be like, how do we deal with that? Because like you scaffold your policy on top of the legal laws. So what we want to use the laws as like a foundation to then make choices where the policy reflects that, because the policy that's our operating manual, right? The laws are the structure. So I don't see why we'd be like, we're never going to make a policy about body cameras because we have laws about body cameras, rather than like the policy we make should reinforce those things. So I would say that we should move forward. And if the committee seems like generally positive about the New York City policy, it's like, let's start with the New York City policy. And one edit to the policy might be, are there places where the policy is in friction with the current laws? Or are there places where the policy is actually a good way to implement the current laws? And then we move ahead where it's not agnostic to the laws, it's building on it.
I agree. You know, our town, I think every town has to have a sexual harassment policy or an anti-discrimination policy, you know, which really defines, like Michael said, the procedure and the process, and doesn't override the law that exists that, you know, that behavior is not allowed or allowable. Okay, so I will, I'll send an email out to everyone. I think everyone has my email address, but I'll send an email asking for input, feedback on the New York City policy. And then I'll take all that feedback and incorporate it into a draft for the next meeting. Does that work for everyone? Give me a thumbs up if you're good with that. Okay, awesome. So is number 4 off the document we've been working on. Again, 2 meetings ago, it was agreed that it's a good thing to have. The sheriff requested that I reword it so it doesn't talk about manipulation and the negative connotations that come with that. And also, so there's something in there, a caveat that allows for, you know, zooming, cropping, those sorts of things if it's in furtherance of an investigation. And the example that was brought up was if there's a video that could be released to the public to help find a victim, a perpetrator, somebody, and by zooming in on their face, it would make it so that the public might be able to help find this person, that was allowable. So I did take a stab at rewriting it. And I'm going to read what was written here, and then I will also email it out to everyone, because I realize just listening to it read is not necessarily going to be able to sink in. But I'm going to read it aloud, and then we can email it out after. So it says, when releasing body camera footage to the public and press, videos must be released with the full buffer mode attached at the playhead and not just once the camera was activated through the event button. The full unaltered footage should be included and not footage that is altered through methods, including zooming, cropping, slowing motion, and any graphical overlays in their official releases. This clause does not apply to internal usage of footage. So if inside the department you need to do all of those things to further your investigation, this is only about the public release. Files can be compressed or converted to a different file type in order to make transferring the file easier, so long as the overall footage remains consistent for the viewer. Footage may be redacted or blurred for privacy reasons. If a redaction occurs for privacy reasons, it must be documented in writing and shall include a description of the redaction and the reason. The written redaction shall be made available to the public, as in why it was redacted. Video stills, including stills with modifications such as zooming in, may be released to the public to aid an investigation. However, if the full footage is not also released, an explanation as to the reason why the full video is not released must be made in writing and made available to the public. So it addressed all the potential concerns that were brought up, and also leaves an area where it can be different as long as the explanation is made in writing. I realize it's hard not having it in front of you, so I will email it out, but just from hearing it, is there any feedback? I want to wait until I email it to everyone.
Sounds like it's well written to me, whoever wrote it.
Yes.
Yeah,
It was not me. I can't take credit, but it is well written.
I think it's a good idea to send it out so that everybody can see it, and we'll just give it a thumbs up next time.
Okay.
I also might like to add an additional point.
Yeah.
I have to believe that the sheriff cannot delegate his duty and his responsibility in these matters as relates to cameras or any other policies to a board such as this.
Yes. And we've acknowledged that multiple times. Everything that is agreed to is the sheriff will be agreeing to it if it's agreeable.
What I'm saying to you is that he cannot delegate his duty with respect to these or any other matters to any third party or any third board.
So I'm sort of following. So you're saying that he has sole discretion on what the policy would look like, not look like, how the video would be handled and not handled. Is that what you're saying?
Yes, sub procedure law.
Okay. So with that understanding though, the sheriff's policies, the policy that we're working on is the sheriff's policy, it's not ours. So the sheriff's policy would sort of dictate what the sheriff is actually has the power to do. It's his policy, he put it in place. So that would more outside of the law. The law is supreme, but the actions the sheriff take would be dictated by his own policy.
Well, he can do what he like the next sheriff.
Correct.
Yes, and DA Cheka, we've definitely
I should say.
We've definitely acknowledged quite a few times that Sheriff Bartlett gets to set policy for his department, and that this implementation committee is, here to have these great discussions of the day. It will be Sheriff Bartlett that decides to move forward with any of the recommendations or discussions that we may be having. Is that what you're talking about?
Not exactly.
Okay. I guess I'm not quite following, but.
Yeah, I know. I totally get what he was saying, but it's the sheriff's policy, so I think the sheriff would have supreme and ultimate say.
Okay,
Yeah.
So go ahead, Dave.
Yeah, I was just going to say, yeah, as Supervisor Hoteling has said, we've been discussing that a lot, that this is an advisory, this is, a state mandated process, and we're doing our best to represent the public and the public's best interest, knowing that ultimately all of these policies will be determined by the sheriff. Okay,
so for that one, I will send out the wording that I just read to everyone, and between now and the next meeting, if everyone can look through it, especially the sheriff, and look at whether you like the wording that has been modified and presented, or if there's any other amendments or adjustments you'd like to see made. And citizen review panel at the last meeting, we started a discussion on that. Sheriff Bartlett talked about the process and the form on the website being ready to go. Captain Breyer, Sheriff Bartlett, did you want to give a quick update? I know that there was one other step that was accomplished between last meeting and this one. Do you want to update the committee?
Since the last meeting, we've all got a new app that we've announced to the public and put out to the public, where it's an app. It goes on your phone, and you can click on it. It's got spots on there where people can file a personnel complaint if they wanted to, or give us suggestions, or there's a lot of spots for feedback, basically, is the easiest way to say that. And we've received a lot of good reviews from people. They like it, and I think the more it gets out there, the more people are going to see and enjoy it.
So, Sheriff, that app, the access that app is posted on your website only, or is it posted elsewhere?
No.
We have links to the app on the website. We've also handed out literature about the app and how to get it. There's currently literature in every county building, along with handout cards and documentation on how people can download the app.
Great. Thank you, Captain Bray and Sheriff Bartlett.
As well as just searching either the App Store or the Google Play Store for Columbia County Sheriff's Office app, and it's under NY.
Cool.
So at the last meeting, we also talked briefly about, what complaints go to the Citizen Review Board. How do they go to the Citizen Review Board? Are there any complaints that don't go to the Citizen Review Board? And to not recreate the wheel, we wanted to look at how some other municipalities have their Citizen Review Boards set up. So I shared 2 documents with this committee as well as on the public website. One looks at Albany and Syracuse, and it's kind of a step-by-step purpose, jurisdiction, composition of the panel, and it looks at the 2 side by side. And then I also included from Syracuse their quarterly report from April 1st to June 30th of 2019, because it was very detailed as far as their mission, their objections, how to file a complaint, public meetings and outreach, board training and education. And I think these are all things that we need to really be looking at and developing. And I do think, and correct me if I'm wrong, if anyone disagrees, the Citizen Review Panel, once we get through body camera, becomes a little bit different. This is something that the chairman of the board created the committee, appointed members, and it's independent and has to be independent from the sheriff's office. Anytime you have a review panel or review board, although I love that the sheriff has gotten the app up and done all of those things, I think a lot of these decisions at the end of the day will be tasked to the full board, but really this committee has a lot more say in what that should look like, and then we can bring that recommendation through the subcommittee and through the full board. That's my interpretation of the Citizen Review Panel process. Does everyone share that it's a little bit different than body camera, which is a sheriff's policy? The sheriff has the say. This is a county committee formed and appointed by the chairman, and so it falls a little bit more under the Board of Supervisors. We're still an advisory committee as the implementation committee, but that this would actually go to the board as opposed to the sheriff for that final.
Right. Yeah, that's my understanding too.
Okay. So I'm just going to review this comparison really briefly in case people haven't had a chance to kind of review it. So in Albany, the purpose is to create an independent review body with respect to complaints of police misconduct and to improve the relationship between police and the community. In Syracuse, to ensure an open citizen-controlled process for reviewing grievances involving members of the police department, provide public accountability, preservation of police department integrity, a forum for citizen complaints regarding police department members to be heard and reviewed fairly and impartially. So I wanted to open it up to a general discussion of this committee, if people have had a chance to review or not review the documents, as far as what direction we were looking to do. In Albany and Syracuse, the jurisdiction is all complaints of police misconduct, active and passive. And I know at the last meeting, I advocated for that. I can't remember if there was others that advocated differently, but that there really isn't like a pre-process, right? There isn't like someone within the sheriff's office that decides whether it's a complaint that goes on to the Citizen Review Panel or not, because that takes away that independent board. And so I would advocate, as Albany and Syracuse both do, that all complaints would go to the Citizen Review Board. DA Chaika?
There's a substantial difference between a city police department and the sheriff's office. The city police departments, be they Syracuse, New York City, Hudson for that matter, are subordinate to the local city government. That is not the case with respect to the sheriff's office. The sheriff is not subordinate in any way to the Board of Supervisors. So any comparisons to citizen review boards discussed in city police departments, I really submit has no place in Columbia County vis-a-vis the sheriff's office.
again, Mr. DA, I would respectfully disagree. Yes, there are big differences between county law enforcement agencies, along as well as state agencies versus local municipalities, whether it's towns, cities, villages, and so forth. There's actually a huge difference. But when it comes to disciplinary actions, or when it comes to complaints, or things of that nature, the process is the same. The outcome may be a little different because of um who they're subordinate to. Um, but at the end of the day, it's either the citizens of the public or the taxpayers actually a lot of the brunt from some of the actions that are taken by uh, um that are taken by some of these complaints. Um, so I would think that, yeah, the boss is different at every level, but the complaint itself and the action and the results of the complaints is very much the same.
Supervisor Beery?
I'm not clear on what exactly, what power, what authority the complaint review board would have over the individual deputy. Are they the ones that are making recommendations to the sheriff for an outcome, or are they the ones that actually are tasked with carrying it out? I can see where the latter is definitely a problem. So if the review panel, review commission, whatever you want to call it, is making a recommendation to the sheriff, I think that's a possibility.
And don't forget, if you're talking discipline, and we're in the middle of discipline, we're also dealing with the union and labor attorneys and everything else involved here. I mean, if we're getting away from the criminal end of things and we're talking about just internal discipline when somebody violated a policy for something, there's a whole separate process for that. Sitting down with her, it may be something as small as, again, your tie clip is upside down all the time. We're tired of dealing with it. Or it may be something that's a major problem where there could be time off given. Or if then again, it works it up higher into a criminal matter, then we would have the DA involved. So there's a whole different play going on here when you're talking discipline.
Well, so and I'm only going on how I envision it. One, when you're talking about internal disciplinary actions, for something that an officer may have done under the context of his job, that's solely your responsibility. That I would assume wouldn't go to a citizen review panel. When you're talking about complaints filed by the public, those complaints would then go in and go to the appropriate categories, whether they're going to your agency or whether they're going to the citizen complaint. Well, they also go to the citizen complaint board, but whether the citizen complaint board is thinking about making a recommendation or something of that nature, it to me would be very similar or very akin to the ethics board, but just an ethics board for police officers, right? They could come out and say, hey, sheriff, we make a recommendation, not getting into the level of discipline that this officer should be. Just make it very general. And this officer should be disciplined, or this officer should get more diversity training or something of that nature. At the end of the day, though, if it is a recommendation such as that, it would be you, the sheriff, that would determine that. And whatever that determination is, you would then have an interaction with the citizen review panel on how you came about to make that determination. Now, as far as criminal goes, I think that the review panel should have no access, no input to anything that would result into something that looks criminal. That's me. I don't know how the other board members feel, but that's where I stand.
And when you look at this comparison document on page 2 under powers and duties, it really, although it's an independent board and it reviews complaints, it's not involved in the discipline. It's really like, for example, one of their powers and duties is to provide data to police department to track repeat offenders as part of an early warning system. Issue the activity reports, statistics, and summaries of complaints, comparison of board's findings and those of the police department. So if consistently the citizen review panel found that there was wrongdoing and the police internal investigation found everything's fine, that might be something to look at, right? So it's not like this citizen review board comes in and disciplines the deputies. They don't have that authority. It's more of a third party, an independent board. While the police department has their own internal process for complaints, the complaints are also shared with this board to do a summary of findings and to compare notes and to say, you know, hey, there's been 7 complaints made on this same deputy. We're going to recommend that the sheriff take a look at that and see if there's something there. So I think when you look at that powers and duties page, that really breaks down, you know, it's not an authority. This board is independent in the sense that the sheriff shouldn't create it, but it doesn't have authority over discipline or anything else. And when it comes to a criminal investigation, that's the DA's purview. That's not, you know, the sheriff or the citizen review panel.
Yep.
DA Cheka?
Nothing that you're talking about could be put in place without negotiating with the union.
I agree.
So once again, even were the sheriff to be subordinate to the board of supervisors, it would still be meaningless because it can't be done without the union, because they're all of this is contractual.
Gary Graziano?
Yes, can you hear me now?
Yes.
Okay, sorry for that. So is creating this citizen review committee part of the overall reform, and is it mandatory to create one of these committees? And number 2, if it is, who will be making these appointments? And is there going to be qualifications or guidelines on who is appointed to this committee?
So yes, it was part of the reform process. It was defined as something to be done. I believe it is required because there was one municipality, and don't quote me on this because I have to look it up, that actually got a slap on the wrist, so to speak, during the review because they did not set up a citizen review panel. The chairman of the board makes the appointments. He already did make those appointments. He has already created a citizen review panel. We could certainly ask him for input as to the composition of the panel and the qualifications. I think that answered all of your questions.
Yep, that's fine. Thank you.
Supervisor Chimides, then Mr. Hughes. You're muted, Michael.
Thank you. I just wanted to emphasize that this process is the next stage of a collaborative police reform process that was created by the Board of Supervisors and Sheriff Bartlett. That this is, you know, I don't see this as an attempt to sort of usurp the power of the sheriffs. I just wanted to clarify the statements made by the DA is that we created a collaborative plan of police reform that I think we're all really proud of, that was really putting forward, you know, moving the county forward with a collaboration that we think is going to improve, you know, public safety and citizen engagement. And one of those pieces was body camera policy, which we discussed earlier, and the police reform panel that we're talking about now. And so I think these are all great questions about what does that specifically mean. But, you know, these aren't like blindside policies that are catching people off guard. These are already things that we agreed that we're going to do collaboratively. So I just wanted to emphasize that this is a collaborative process, and it's not about usurping one agency's power over another's.
Yeah, and that's the point I was going to make. That's exactly right. The attempt is not to usurp the power of the sheriffs and or the unions. In fact, you know, I when I was on the board, I worked with Supervisor Grattan, or Chairman Grattan at the time, to develop the Labor Management Committee. And so between the Ethics Board and the Labor Management Committee was very similar to something like this. And basically on the Labor Management Committee, all complaints that dealt with employees went to that committee and recommendations were made. And the unions didn't have a problem with it. And in fact, the unions really appreciated the fact that there was an outlet where complaints could be reviewed by somebody other than the administration and the labor. So it was an independent, you know, elected officials, but you also have people from the outside. So it was independent of the administration and independent of labor. And I think this will operate in a similar fashion. I just think that it's not trying to usurp anything, and this it would be a real benefit to have it, I believe.
Thank you, Mr. Hughes. So I do want to leave a few minutes for public input. I'm first going to open it to any other supervisors or members that are on the call. And if you're watching from the public on the YouTube link, if you have any input or questions, just put it in the chat box and we're going to go to you next. So Supervisor Collins or Supervisor Mussman or anyone else that's on the call, Supervisor Benvenuto. And I do ask that all comments be relevant to topics that were on the agenda for today's meeting. Okay. Oswaldo, is there a way for you to go to the YouTube link and check if there's anything in the chat box?
Yep, sorry, I had to unmute.
Thank you.
Yes, there are some questions. You just want me to read them off as they are?
Do you mind?
Sure. So here one says, Citizen Review Board, the 3 independent police departments are subject to it, or can they opt out depending on the case, or opt out for permanently?
Does anyone know an answer to that question? I will say that the collaborative process of police reform was with the input from all the police departments, and one of the agreements was a citizen review board, and so every police department agreed to and signed off on the plan as written, which included a citizen review. And also, I think they've already opted in, would be my guess, but I can certainly look into, you know, the requirements thereof.
If I could, I would imagine that the municipalities, the affected municipalities would have to sign on if they wanted to do that, or they could form their own.
If I remember the discussion right, that we were talking about having a combined form that was very similar to the one that the sheriff was generating, that would go into all the police stations and town halls and so forth for citizens to file a complaint. What wasn't readily talked about is, would those towns also have a mechanism to address those complaints? And so that was kind of being pushed down the road of whether it would end up in the overall when he was putting together. But then the statement from the governor's office was, if the towns signed off on, because they didn't develop their own committee, if they signed off to be a part of this committee, then they were going to have to adhere to the policies that were developed by this committee.
It would make sense to me that if we're going to do anything and try to exercise any jurisdiction over any of those other municipalities, then they should be invited to be at the table. They should know what we're talking about.
Yeah.
Yeah, I can look into that. I mean, it definitely lists them as opt-in agency partners, and they were part of the reform process that created the plan that calls for a citizen review panel. So they were at the table for the decision, but I think what you're saying is they should also be at the table for the development when we come to different, this idea versus that idea, which I think is a valid point. And I can look into a definitive answer on the question as to whether a police department can opt out. My guess would be no, but that's just me guessing. And I will also look into, I believe that the citizen review panel was one of the requirements, not just in our plan, but that the state put out there. But I will look into that and have answers for next time. Oswaldo, do you mind reading the next question?
I think that's all the questions right now pertaining to the subject.
Okay, great. Anything else from any of the implementation committee members? All right, thank you all so much for your time. We are meeting again in 3 weeks on the 26th at 1 p.m.
Okay, thank you, everyone.
Thanks, everybody.
Thanks, everyone.